And thank you for your patience. I'm not sure what's up, but we're here to serve. So, first of all, gentleman on the end, what's your name, sir?
Daniel Kelly.
Okay. Mr. Kelly, this is case 3PA-13-03218, single count of assault in the 4th degree. And do you have a copy of that?
Yes.
And have you read it over, and do you understand what it says?
Yes. Yeah. Well, yes and no.
Okay. Well, and my question is not whether it's accurate, but do you understand what it says?
Yeah.
Okay.
And not accurate, but yeah.
And when you say yes and no, is there some part that's...
That's what I was saying. Yes, I understand, and no, the part is there's a couple of inaccuracies that really...
are important?
Important, yeah. Really are.
All right. Well, the main thing is that you understand it so you can spot those kind of issues.
Right.
And is that the correct spelling of your names at the top?
As long as it's Kelly Evi.
Evi, right. Daniel, common spelling.
Yeah.
Middle initial M. And your date of birth?
1979.
Okay. All right. This is a misdemeanor charge, and the maximum sentence on a Class A misdemeanor is a year in jail and a $10,000 fine. There's not a mandatory minimum sentence. I'm sorry. Okay. All right. And Ms. Hughes?
Yes.
Yes, this is Judge Estelle. We're on record in the district court, and this is the time set for an arraignment for Mr. Kelly. And thank you for taking our call. We need to go over the preliminaries, and then when we get to the point of addressing bail and conditions of release, I'd be glad to hear anything you wish to say about recommendations for conditions, whether you want a no-contact order or want restrictions of some sort, and have other information that might be helpful. But you don't have to say anything if you don't wish to, and you're more than welcome to listen in. So we'll go through the preliminaries. This is a Class A misdemeanor, and I've advised Mr. Kelly what are the potential sentences, and it appears that there is no mandatory minimum sentence in the case. So with that, Mr. Kelly, do you have a lawyer, or do you wish to have one help you with the case?
No, I don't.
Okay, and let me go through the questions with Mr. Kelly first, and then Ms. Hughes will take your statements next. Thank you. So with that, Mr. Kelly, do you have a lawyer?
No.
And do you want one to help you and give you advice on the case?
Yes.
And do you intend to hire one, or do you believe you may qualify for a public defender?
I do qualify.
Okay. And are you currently receiving public assistance?
Yes.
Okay.
Great disability, too.
All right. Okay. Based on that, I'll appoint the public defenders to represent you. And the clerk has some paperwork with their contact information and phone number. Their office is right next door to the courthouse in the state office building. It's the white building with the green roof connected to the courthouse. So call them and let them know they represent you, and give them your contact information. And what is your current mailing address?
It's 2085 North Willow Drive.
Okay.
That's correct.
And
Yes.
what's the zip code?
99654.
Yeah, that's Wasilla. Okay. All right.
And that's not what it says on this, by the way.
And the printout says 2085 North Willow.
Zip code's wrong.
99654, and it should be 99.
It should be 99654. It says 99645.
Okay. On which are you looking at? The I see. Okay. 99. Right. I understand. Okay. I will go ahead and amend that on record. I don't know who it was at the post office that decided that Wasilla should get one that has such a close resemblance of Palmer's only zip code. All right, thank you. And So contact the public defenders within 5 days. I'll enter a not guilty plea at this time to preserve your rights, and the case is assigned to this court. The speedy trial clock starts today and will expire March 24th. And so, and in this case, the state's alleged and would have to prove that, based on your words or conduct, that you placed her in fear of imminent physical injury. Physical injury means physical pain, and imminent means about to happen. Physical pain or impairment of a body condition like bruising, that kind of thing. And that you, even if you didn't do it intentionally or knowingly, that you at least were acting recklessly, that might be the result. So that's what the state would have to prove. And there is probable cause. I'll set a couple of dates, and Mr. Kelly, the first date is a pretrial conference, and that's a hearing that the public defenders could appear for you if you sign what's called a consent to proceed in your absence. At scheduling hearings, they can do that, but you have to go there and sign their form. The pretrial conference is a hearing to make sure the case is being properly prepared. That is, that the state is given a copy of the police report, which is a longer version of what happened, and also any recordings, things like that. So that hearing is to make sure that your attorney is getting all the information they need to give you advice. The second hearing is a trial call, and if you wish to resolve the case with a jury trial instead of some sort of a plea, then that's the time to ask for a jury to be brought in to hear the case. So we'll set those 2 dates today, and you can talk to the public defenders further about that. So we'll set the pretrial conference approximately a month out. That'll be 12/24 at 1:15. That's December 24th.
Is there any way to do that on a different day? It's
Well,
like Christmas Eve.
Yeah,
I may not be in the state.
Right, but you, as I indicated, that's a scheduling hearing where you wouldn't need to be here.
Okay.
If it's a trial status or trial, you'd have to be here. But in order for them to appear without you, you have to sign that consent form for them. And they will have somebody here on that day, but
Really?
hope it's part of the job, I think. And so then trial call will be January 24th at 9. That's 1/24/14 at 9 a.m. And these dates and times will be on the paperwork the clerk gives you. So with that, turning to the question of bail, there, first of all, Ms. Hughes, as far as conditions of release and so forth, and different things that you might suggest, do you have anything you wish to say, any requests or suggestions? I'm sorry, Ms. Hughes? Maybe we're on mute. Ms. Hughes, are you still with us? And Ms. Hughes?
Yeah, I'm sorry, I got disconnected there.
Yeah, that's quite all right. Returning to the question of release conditions, do you have any suggestions or requests?
I did want him to be on third party, but I don't know if that's possible for him because I don't know if anyone will third party him. I do not want him to resign in the same residence as me. as I do have my daughter here. She's only 2, and with his actions yesterday, I don't feel safe with him in the house.
Okay. And there is a statute that actually says that at least for 20 days he cannot return to the residence, and that's something the court has to order and doesn't have any control over. So that would be one. As far as you do not have children together, correct?
No.
Okay. And according to the summary in the complaint, it says that he's lived at your residence for approximately 6 months, but that was your residence previously, correct?
No, that wasn't correct. I've only been up here for a couple months.
All right. Okay, so it was his residence, and then you
Can I say something?
moved. Yes, you'll get a turn in just a minute. So, Ms. Hughes, the way the statute reads, he can't go back. Do you wish to be able to have phone contact or any other sort of contact not in person? So there are different things. One is not returning to the residence. Another is typically there's no contact pending further court order, so that there's no pressure either intentionally or unintentionally. I mean, he doesn't want to be in a position where it looks like he's trying to put pressure on you to say something or change your statement or anything like that. It wouldn't look good for him. So typically we have a no contact order until he's talked to his attorney and you've talked to the DA's office. But do you have any requests or suggestions as far as contact? Is there any reason other than perhaps him getting some of his things that you would have need any contact with him?
I don't need any contact with him, no.
And if he needs personal possessions and can't go there, is there somebody that you could arrange if you need to give him things that he needs?
Yes. We have someone who can get him his things.
All right. And he wouldn't have to have contact with you to set that up. You could call them?
Yes, we could call him.
All right. And that person's not to be relaying messages back and forth. You can explain and just ask him to deal with the things, but not to talk about the case.
Okay.
All right. Are there any other issues, drug or alcohol issues, that the court should be aware of?
No.
Okay. All right. And the people living there were Mr. Kelly, you, and your daughter. Is that correct?
Everyone that's living in the house?
Yes. Is that just the three of you?
9 people in the house.
No, there's more people in the house. It's not just me and my daughter.
I see. Okay.
They don't have a lease either.
Okay. Well, in any event, he does have a lawyer, so he'll be contacting his lawyer and talking to them hopefully tomorrow, so we can get further advice. That you should call the DA's office. They'll have further information for you about the case and about your rights and explanation about the process, and they'll probably call you if you don't call them first. And they're in the phone book, so they may be helpful. And as far as the third-party custodian, do you believe he might not come to court or might violate conditions of his release and so forth?
I honestly don't know. I don't know him that personally.
All right. Okay. Well, it appears he doesn't have any prior criminal history, and that he's been in the state for at least a couple years. There's the earliest thing was 2010 that shows up here. Out-of-state Social Security, and there is there was a NACNEC case, a restraining order case from 2010. I'm not sure what that is about.
That's actually still in Anchorage Court.
Okay, and you don't have to say anything about that. That's looks like 3NA-10-3906. But that doesn't look like a DV case. Clarence Golodoff was the...
Right.
But no criminal convictions. So I think this is not the sort of case that the court typically imposes a third party, but I will impose conditions, and it's a misdemeanor crime for him to violate any of the conditions of release. I'll set bail at $500 cash or corporate. That means you can have a bondsman put up the bail, or you can post the cash, and if you appear in court as scheduled, you would get that back at the end of the case. However, there are conditions you must follow. They are that you obey all laws, that you maintain contact with your attorney, and it's your job to keep track of your case and stay in touch with them. You have one case, they have lots, and you can keep track of your dates on the internet at the court system's CourtView website as well. You're to notify your attorney within 24 hours of any change of address, so wherever it is that you are residing, you need to let them know and then tell them immediately if that changes. You're to appear in court as scheduled, not return to the residence pending further court order.
Ask a question about that?
And you can talk to your attorney about how that works. And I'll give you a chance to ask the question here shortly. And no contact direct or indirect with Ms. Hughes pending further court order. And she can contact somebody to discuss picking up your things. Do you know who you would be calling, ma'am?
His PCA.
Okay. And so, does that work? They'll be able to work that out?
That's her mother.
Okay. And
that's the one who lives at the house, too. She's my PCA.
And, all right.
That's personal care assistant.
Right. And will she be...
Yes.
I mean, with 9 people in the house, there's no reason why she has to be there.
Well,
because like when something like this happened before with the Kolodoff thing, I was allowed to go to the house to pick up my things as long as there was an officer present.
Well, that was a civil case.
Okay.
And in civil cases, the writ of assistance works. But the statute is what it is. But you can arrange. So
I can't physically go in there and get my things out?
Right. That's basically what the statute says, which is difficult, but there are ways to work around it. So you believe she'll be able to do that, gather things, and
I'm on a lot of medication, you know?
And you want it to all appear and none of it to disappear.
Exactly.
And so forth. And I'm sure, given that she's a professional, she'll make sure that happens. Is she being paid to live where you're living to do the things that she's doing?
I'm not sure exactly how it breaks down.
Okay. Well, you can talk to her. In talking to her, don't relay messages, don't talk about the case, what happened, what people said happened, what they're going to say happened. You just don't want to be talking to her about this incident, but about as far as to your PCA. About, I mean,
okay.
I mean, about what happened. You can talk about what you're doing going forward.
Because she's going to be the one helping me with all this.
Right. But you don't want to talk to her about the incident. You don't want to communicate and relay messages or, what happened. You can talk about how to deal with the circumstances, but just don't be discussing the case. And that's just, you can talk to your attorney about that. They'll give you better advice.
Okay.
Just sort of broad brush. Okay, so with that, Ms. Hughes, you believe you can talk to your mother and make arrangements and have your mother contact him to find out what the situation is? I mean, he's
Your Honor, I'm right here.
Yeah.
I didn't catch everything.
All right, you can talk to your daughter, ma'am. Basically, logistics, if he decides to post bail and he's not able to come back to the residence for at least 20 days under the statute, and the court doesn't have any power to change that. But if he does post bail and is no longer staying...
What is his bail?
It's a $500 cash or corporate bond, but then there are conditions that he not have any contact with Ms. Hughes, that he not return to the residence, and other things.
Okay.
But that means that if he's not there, he's going to be living somewhere else, and if you're the PCA, that may...
Well, yeah, I will help him. I will help figure out someplace for him to go. I'm not going to allow him to be homeless.
Yeah, and he mentioned needing to make sure all his meds are protected and delivered and so forth. So
Right.
You can work on that. He's going to contact his attorney tomorrow and then get further advice. So we've set dates, and with that, Mr. Kelly, any other questions at this point?
Is Daniel going to be allowed to call me to talk about attempting bail?
Yes. Well,
Okay.
he can call and talk to you about things other than the case and what happened. As far as moving forward, bail, living situation, getting his things, you just don't want to be in a position where it looks like you're talking about what happened or what people said or what they're going to say.
That's fine with me.
So it's all about moving forward, not about what happened. So
Absolutely. I will go with that.
okay. And anything else at this time?
Hotel in Palmer?
Yeah. Well, you're a guest of the state at this point, but my guess is DOC is not going to cooperate a lot as far as getting the meds, so that's probably a priority. You can ask the people there and see what they can do.
That he's not cooperating on getting meds?
I don't know whether DOC...
I haven't been able to get any meds since I've been here.
That's the rub, is he needs to talk to the people there, or if he bails out, then you'll be able to get him back his medications. So the next hearing, if there's no other request, will be a pretrial conference, December 24th, and as I indicated, you can sign a consent to proceed, so you don't have to be here on that date. That's at 1:15.
On Christmas Eve, really?
Well, the public, since this is a misdemeanor, he can sign a form called a consent to proceed in his absence, so that the public defender that appears can be here for him, and he wouldn't have...
That will be easiest since he doesn't drive,
Yeah.
and I don't know what the situation will be if he will still employ me after this.
Yep.
If he doesn't employ me, I'm not going to take him to court. So.
Well, I understand, but be that as it may, he can talk to his attorney about that, but he does need to get that form signed so that they can appear on his behalf.
Right.
Okay?
Okay, rest assured, Daniel, I'm not going to let you be on the street. Okay?
See you soon.
It's good to hear
Okay.
support. Thank you. And
Thank you, Your Honor.
if
Bye-bye.
there's nothing else, Ms. Hughes, if there's nothing further, you may be excused and hang up. Okay, thank you. Next.